I came on. The last one's supposed to be next door too. Okay.
So
Okay.
on your Zoom,
Okay. You all gonna stop sending out them text messages with my, just stop putting my name on there.
Yes, Your Honor.
Okay.
right? All right, that's the one.
Okay. Ready on Davis. Person that's in the right place. Ms. Cummings, unmute and state your name.
Oh, Jessica Cummings.
Thank you. Accept the joint breakout room, Ms. Cummings.
Okay.
Ms. Davis, start your video. This is case number 204477502. The people of the state of Michigan versus Brianna Cara Brianna Davis. Defendant is charged with 1 count of assault or assault and battery, and today is the date set for an arraignment on the bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. For the record, Janice Stevenson appearing on behalf of Ms. Cara Davis. Ms. Davis, ma'am, please unmute and say your full name.
Kara Davis.
Your full name.
Kara Brianna Davis.
Today is the date set for a pretrial conference. The register of action is 8 pages. How are we proceeding?
Stands mute, Your Honor. Waives the reading of the information asked that a plea of not guilty be entered on Ms. Davis's behalf, and we'd ask this matter be set for a pretrial conference.
The court is going to enter a not guilty plea as to the arraignment on the bench warrant. And I will set it for a pretrial conference. How many do I have on March? I'm sorry, February. Just so you know. I'll be asking a lot of questions. And I should
24.
I'll set the matter for February 7th. That's gonna be. um, That's gonna be at, 8:34. And I wanna address one.
Yes, Your Honor.
This is ridiculous. This is ridiculous. Can you all hear me clearly?
Yes, Your
ma'am.
Honor.
This is ridiculous. Now, I made a point to say that the register of action was 8 pages. And then I took the time to count how many times Ms. Davis has failed to appear. And it is no less than 6 times. Ridiculous. Ridiculous, ridiculous, ridiculous. Absolutely ridiculous. Now, she can fail to appear if she wants to again. Clearly, she just keeps showing up to get her warrant set aside. But I got news for everybody. This is ridiculous. Ridiculous, ridiculous, ridiculous. So 2 things are getting ready to happen. She's going on a tether. Now, I'm adding the tether. She's gonna present herself for the tether. Should she fail to appear to present herself for the tether, then her bond is immediately going to be raised. So that when she is either arrested on the warrant or decides to sashay in again to get the warrant removed, her bond is she's gonna have to post a $10,000 cash surety plus GPS tether bond. Because this is ridiculous. And literally, for the record, she was originally arraigned in 2020. She was scheduled for a pretrial conference July the 20th, and she failed to appear. She failed to appear July 20th. Matter was rescheduled for August the 30th, and she failed to appear August 30th. A warrant was issued for her arrest. August 3rd, excuse me. A warrant was issued for her arrest, and then she showed up again, April 2021, and she was arraigned, and then a pretrial or an arraignment on the bench warrant, something was scheduled for May 1st. And she failed to appear. And then, instead of me issuing a warrant for her arrest, I scheduled her for June 14th. June 14th came, and she failed. Oh, I'm sorry. Let me give her credit where credit is due. She showed up. She showed up June 14th, and then I scheduled it for pretrial for July 21st. So she showed up one time. July 21st came and went, and she failed to appear. And I issued a warrant for her arrest. And then she showed up again in August. And then I reinstated the bond, and I scheduled her for September the 8th. And on September the 8th, she failed to appear. She failed to appear. But no, I didn't issue a warrant for her. Oh, I gave her another chance and I scheduled it for November. And then in November, she failed to appear. And a warrant was issued for her arrest. And then she showed up last year. Strike that, I'm sorry. 2022. She showed up July 2022. The magistrate arraigned her, gave her a court date. She was supposed to come September the 12th. September the 12th came and went, and we didn't see Miss Davis. She failed to appear. And then a warrant was issued for her arrest. She showed up again in December. They gave her a court date. She was arraigned on the bench warrant, given a court date for January 2023. January 2023, for the 7th time, she failed to appear. Number 7, failed to appear. Okay, we issued a warrant, still gave her a low bond. Still gave her a low bond. And then she sashayed in at the end of the year, last year. And then they gave her this court date. Now, if I'm the only one think that's ridiculous, I know I'm not. So her bond was that little measly $100, 10%. Well, now her bond is $100, 10% plus a GPS tether. The GPS tether curfew hours are from 11 p.m. to 6 a.m. She has until the close of business today to present herself for this tether at the Detroit Detention Center. And I'm going to put this on the docket for tomorrow. And if she has not presented herself to the Detroit Detention Center for that tether, her bond is $10,000 cash surety plus a house arrest GPS tether. So we're gonna set the matter for a bond hearing tomorrow at 9:04 a.m. This is ridiculous. This is ridiculous. Anything further?
With that being added, we're asking for no contact for me.
Absolutely no contact. Absolutely no contact.
Nothing on behalf of Ms. Davis. Thank you, Your Honor.
All right, somebody needs to send one of them text messages y'all sent and let her know how to get to the DDC. She better get to the DDC and get that tether. She better get to the DDC and get a tether today. And if she don't show up, I'm gonna issue the warrant. I'm gonna issue the bond, and I'm gonna send the police to get her.
Understood.
So-
We'll give Ms. Davis a call right now, Your Honor.
Yeah. Okay, then we're all set. Have a great day. Stay safe and get to the DDC.
Yes, ma'am.
Hurry up and do that order. So she can get over there. As soon as she get there, I want it, so the order to be there, we can send it over to the tether unit, the DDC, however they doing it. She need that tether. And Ms. Stevenson, you all need to make it clear to her, if that means she has to go in custody to get to Tether, she better go in custody. They just gonna put her in custody. She better
Yes,
get that.
Yes, Your Honor.
Okay. Let's see, Ms. Johnson and Ms. iPhone. Did she bring up any? Yes, ma'am. Did she bring up any funds?
She brought two. And Brenda Johnson.
Seemed like when they put them on your docket, they would just send them files.
Yeah. This one here, Barry Dixon. Defendant number 2 is at final pretrial February 9th of that file. In the cat.
Oh, it's filed in the county, that's cool. I thought they keep cases.
This is, they print off like some more stuff for defendant number, for this defendant.
Right, but I'm saying, I thought they kept, with it, one.
Anymore is there.
They don't know, they. Okay,
I do have to buy that file for that.
can the person on the iPhone please unmute and tell the court your name?
Deontay Calloway.
Did we just want to tell him?
Pardon me?
Why is he back in my courtroom? Mr. Calloway, didn't you just talk to my clerk?
Yeah, she had, I believe. I
No,
think she
first of all,
actually-
she nothing, because my clerk is a man. You just spoke to my clerk on the telephone, and he gave you instructions about where you're supposed to be, and it's not here. So follow his instructions. I'm ready on Johnson.
Ready on Johnson, Your Honor.
This is case number 174464501, People versus Brenda Faye Johnson. The defendant is charged with 1 count. Don't give him the instructions again, but, okay. 1 count of assault or assault and battery. Today had 4 retrial conference appearances, please.
For the record, Your Honor, Christina Rivera on behalf of the people.
Janice Stevenson, appearing on behalf of Ms. Brenda Johnson. Ms. Johnson, ma'am, please say your full name.
Brenda Faye Johnson.
Today is the day set for pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. Johnson, we would move for dismissal for the complainant's failure to appear.
Well, isn't it supposed to be in the envelope saying non-public? Ms. Ritter.
Your Honor, the court did arraign this matter and set a pretrial conference requiring the complainant witness, Brianna Johnson, to be present. I don't see Ms. Johnson in the waiting room, Your Honor, and the people don't have an explanation as to why Ms. Brianna Johnson is not present. At this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear before the pretrial conference as required by the court.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. People have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. Ma'am, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you.
Thank you, Your Honor.
You're welcome. I'm ready on the van. This is case number 20450870, the people of the state of Michigan versus Ebony LaKaya Van. The defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Ms. Ebony Van. Ms. Van, ma'am, please say your full name.
Ebony Van,
And what's your full name?
Ebony LaKaya Van.
Today is the date set for a pretrial conference. How are we proceeding?
On behalf of Ms. Van, Your Honor, we would ask that Ms. Van will continue her plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery, Your Honor.
The court continues a not guilty plea on behalf of Ms. Van. I set the matter for a final pretrial conference. April the ninth, 2024. Anyway.
Just 2 that day.
Can you go to 8 or 8 to tell me what jury trial that is? Which jury trial those are?
Alicia Williams. Yes. That's my son. Sorry.
Discovery should be submitted to defense by March the 8th. Bond will continue. What is the current no contact or contact review? And if I didn't say it, of course, the final pretrial conference is at 9:00 a.m.
So, Your Honor, if I may, I would ask the court, I don't see the contact condition, but I would ask the court to set no assaultive contact. There is.
Ms. Dickinson, can I get the answer to my question first from my clerk, please?
Oh, yes, Your Honor. I apologize, Your Honor. I apologize for that.
You gotta take over spirit today.
Yes, Your Honor.
What's the contact review?
That's correct, Your Honor. There is not one in our.
What do you mean? So the bond says what?
There's no bond.
Who was the magistrate?
Looks like it was done by Judge Williams.
Ms. Ritter, what's your position?
Judge, well, from the people's understanding, it looks like the complainant is now 20 years old. I don't have any notes indicating that, there isn't any contact between the 2 parties. So I'll leave it at the discretion of the court because of the complainant age.
All right, well, court will set the contact provision as no contact. I'm sorry, no assault of contact. Anything further?
No, thank you, Judge.
Nothing on behalf of Ms. Van. Thank you, Your Honor.
All right, then we're all set until April the 29th at 9:00 a.m. Ma'am, have a great day. Stay safe and happy.
You too, Your Honor.
Thank you. Ma'am, adjust your camera. Turn your camera back on. And then adjust it, so I can, there you go. This is case number 184504401, the people of the state of Michigan versus Ashley Sherry Moman. The defendant is charged with operating while intoxicated and driving while license suspended, revoked, or denied. Second offense notice. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Rivera on behalf of the
Janice Stevenson, appearing on behalf of Ashley Momon. Ms. Momon, ma'am, please say your full name.
Ashley Moment.
Please say your full name.
Ashley Shiree Moment.
Today is the day set for pretrial conference. I'll let you see you.
Your Honor, Ms. Momon will continue her plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery.
The court continues a not guilty plea on behalf of Ms. Momon and set the matter for final pretrial conference, April 29th, 2024 at 9:00 a.m. with discovery being submitted by March the 8th. Bond will continue with no contact with complaining witness. OWI, no drinking and no driving without a valid license. Anything further?
nothing.
Nothing on behalf of Ms. Momon. Thank you, Your Honor.
All right, we're all set until April the 29th at 9:00 a.m. Ma'am, have a great day, stay safe, no drinking and no driving without a valid license.
Okay.
Mr. Dixon, start your camera, sir. Mr. Dixon, start your camera, sir.
Can you check and see if you can let us out?
Please state your name for the court.
Shatonia Bentley.
Ms. Bentley, what time was your court hearing today?
It was at 8:30.
And what time is it now?
It's 9:30.
Why are you late for court, Ms. Bentley?
because I work a midnight job and I didn't get off till 6:30 this morning.
Okay, that math doesn't add up to me. You got off at 6:30 and you had a court hearing at 8:30.
Yes, ma'am, I fell asleep.
Logging in.
I fell asleep, and when I woke up, I had to re-download Zoom and get back in so that I could attend Zoom.
Wait, when I tell you this, so start your camera. Let me be able to see your face when I tell you this.
I keep trying to unsee it, but it won't. Okay, there it is.
Number one, you in the bed and you attended to my court. Number two, you already said that you were sleeping. That's why you didn't come to court on time. Number three, the fact that you went to work is your problem, not mine. You had a court hearing at 9 o'clock. I mean, at 8:30. If you don't know, number one, how to get here on time, and number two, how to come correct when you do come, ma'am, don't come. Don't come. A warrant is just gonna issue for your arrest, and there's a place I can guarantee you that you're gonna log in. I won't have to worry about if you sleep. I don't have to worry about if you had to work, and that's from the Wayne County Jail. So, okay, that's all I have to say. She's an hour late, she's not apologetic about being an hour late. She's an hour late and in the bed. Now, I wonder if I wanted to stay in the bed, because I've been up since 2:30 this morning. And I'm thinking I wanted to stay in the bed too.
I'm not apologetic, Your Honor.
Don't worry, it's not a conversation. It was just me telling you that I'm gonna issue a warrant for your arrest if you show up again an hour late to my courtroom. Furthermore, you're going to get out of the bed. So I'm gonna send you to a breakout room. The attorneys are gonna assist you, and you're gonna get out of the bed. And
okay,
not
no
come
problem.
back to the room disrespectful. Please accept to join the breakout room. Mr. Bird, are you able to do, who I believe is Mr. Dixon in the waiting room, because he wouldn't turn on his camera and now he came back?
I am, Your Honor.
Please unmute and state your name. Please unmute and state your name.
Barry Dixon.
Now, Mr. Dixon, why didn't you turn on your camera when I was ready to call your case and I asked you 3 times to turn on your camera?
No excuse. I never turned it off. My screen timeout must have took effect.
I guess it's still time for me to hear new stuff all the time. Because when your screen take effect, you just tap the button and then you push turn on your camera. Okay, I mean, yeah, let's go with that. Are we gonna wait for your screen to take effect now? Okay. This is case number 20-444-6601, People versus Barry DeLorean Dixon. Defendant is charged with 1 count of retail fraud. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Rivera on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Barry Dixon. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Sir, state your name, please.
Barry Dixon.
Today is the date set for an arraignment on a bench warrant, and Mr. Dixon's register of action is, it's only 4 pages, so it's not as long as, so he was arraigned in 2020, scheduled for a pretrial. Pretrial was held, it was scheduled for a final pretrial. Then, final pretrial was adjourned. Oh, that was because of COVID. Final pretrial was adjourned. And then, final pretrial was held. Oh, but he didn't appear, so he failed to appear one time. That was in 2020. And then we adjourned it. And then he still failed to appear. And then he showed up in 2022. He was scheduled for pre-trial. He was arraigned. He was scheduled for pre-trial September. And then September came and he didn't appear. That's the third non-appearance. And then I didn't issue a warrant and I scheduled him for October 19th, and then October 19th came and he failed to appear. That's the fourth failure to appear. And then he showed back up in 2023. November 2023. And let's see. And maybe not. This is an old register. So I don't know. Somebody printed this register in December. So he was scheduled, he was arraigned in December, and I guess they gave him this date. All right. For the fifth time, the court will set aside the warrant, recall the KBS, and set the matter for another final pretrial conference. And I guess we'll see if he show up. I guess we'll see if Mr. Dixon says, I'm gonna show up, or I'm just gonna keep being a running man. Court is gonna set the matter for final pretrial conference. Who's the claim with?
Minor judge may appear there.
Yeah, they appear. They always appear. No, they don't. They don't always appear, Mr. Real. Yeah, Meyer did appear this morning, even though it was an arraignment on the bench warrant. I'm gonna set the matter for final pretrial conference. Ms. Ritter, I guess she can submit the discovery. And final pretrial conference is going to be March the 7th at 9:04. Failure to appear will result in a KPS being issued, a warrant being put out for Mr. Dixon's arrest, and his bond being set at $5,000 cash surety plus a GPS house arrest tether if he fails to appear. Anything further?
No, thank you, Judge.
Nothing further, Your Honor. Thank you.
All right. We're all set until March the 7th. Again, have a great day and stay safe.
Thanks, you too.
Are you ready on Cummings, or is that something Ms. Stevenson? Oh, she's here. Did somebody go in there and get Ms. Bentley out the bed?
That's what I'm doing right now, Your Honor.
Okay, go.
Your Honor, Richard New and Bonita Brooks are in the hallway.
What time they in the hallway? Who?
Richard New.
Oh, they in that hallway. What, 9:44? How long they been in the hallway?
Bring on.
Richard New and who?
Bonita Brooks. Trial.
Oh, Ms. Brooks is all right. Okay, are we ready on Ms. Cummings? Ms. Stevenson? Okay, See, you can't in here now to see this.
Yeah.
And look at this list of estimates. Can. Oh, okay, here she is. This is case number 194600601, People versus Jessica Teresa Cummings. The defendant is charged with contributing to the delinquency of a minor. Today is the day set for sentencing appearance.
For the record, Your Honor, just so that we have.
Janice Stevenson appearing on behalf of Ms. Jessica Cummings. Ms. Cummings, ma'am, please tell the judge your full name.
Jessica Teresa Cummings.
Today is the day set for sentencing. With respect to sentencing, is there anything on behalf of the people?
Yes, Judge, so I see that, this case is scheduled for 8:59, which indicates some people that there was no side word in this matter. Looking at the investigative report, Judge, and just to give the court a background of what this case is about.
Well, let me interrupt you. So we gave Ms. Ritter this unification plan, right?
So I did not, Your Honor.
Oh, well, she has to have it.
Well, here, she can have this one. I'll print another one. Excuse me, Your Honor.
Ms. Ritter, I'll give you time to look at it.
Thank you.
Mr. Camacho, 945, he paid.
Oh, yeah, and it was something else though, but, it was something else he was supposed to.
Oh, okay.
Was it the $10? Wait, was this the one that was $10?
Yeah,
Okay, yeah, he loves that.
okay.
In the middle of update this form, I see it update. The Atlantic States with Attorney Miller. I'm setting, I need to set a show cause for Attorney Miller. So, and it has to go on one of those several files or whatever, so you ask me. Night, how to do a show cause. All right, we're back on the record. Ms. Ritter, you may proceed.
Thank you, Judge. So, Judge, the people didn't have an opportunity to review the unification planning from the Child Protective Service proceedings. And at this time, Judge, I don't see that there was any plea recommendation from the people. So the people are recommending that there at least be 6 parenting classes with the term of probation. It looks like the child in question of this case is back with the mother, so we're not going to ask for any no contact order.
What's the child's name that was the subject of this
Jamari Cummings. And according to the plan, there's all of the children, because there are other children involved in the proceedings for the reunification. It looks like all the children are back in custody of this country. So we're not gonna ask, for the no contact order, Judge, but, we do ask for some parental classes, because of the circumstances of this case that happened in 2019 involving Jamari Cummings, who was 5 at the time.
All right, let's see. You're muted.
Thank you. I believe with the order that the court and the people do now have, the court is should be satisfied that that the complaining witness has been in the care and custody of his mother for the last several years at this time, Your Honor, and they don't have any new cases going on. So I'm going to ask the court to follow the people's sentencing recommendation.
Would Ms. Cummings like to make a statement on her own behalf?
Ms. Cummings, if you would like to say something, ma'am, could you please unmute?
No, I don't have anything to say, but I did complete 12 parenting classes prior, which was part of me getting my kids returned home.
You don't have anything to say? Ms. Cummings, you don't have anything to say?
No, I just stated that I did complete parenting classes prior to my kids coming home.
I heard you say you did parenting classes. I'm just was asking you again if you had anything else to say. That's what I was asking.
Oh, no, I don't, Your Honor.
Okay. All right. Well, that's disappointing to me. And I know people don't have to speak, right? And we are post conviction and ready for sentencing, and so I know people they don't have to speak, but that's so disappointing to me that Ms. Cummings doesn't have anything to say other than I already did parenting class. I already did parenting classes, and I learned a lot about what I did wrong as it related to my son. I am remorseful that I put my family and my children in that situation. I've learned my lesson. Like literally, it's my turn to speak now. I'm not interested in anything you have to say now. I asked you twice if you had anything to say, and then you didn't. So I'm ready to impose sentence. And I'm gonna do so in the following manner. I'm gonna place Ms. Cummings on probation for 12 months with a final review date of January the 9th of 2025. And an interim review date or first review date of May May 9th, 2024 at 1:30 p.m. with the following terms and conditions. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent from this court. You must make a truthful report to probation on a monthly basis. or as often as they require, either in person, strike that. As often as they require, you must notify probation immediately of any change of your address, phone number, or employment status. And, I guess the court, I should have said, I did have an opportunity to review. It's not the reunification plan, so that's not what I have. I don't have the reunification plan. I have the order after dispositional review, permanency planning hearing. So there's no way for me to know from this document what her requirements were in order to reunify her family. But I do assume that they probably had her do some parenting classes. I assume that a person would get reunified with their family without doing parenting classes. What I'm disappointed at is that doesn't sound like she, well, okay. We're gonna do some more parenting classes. But the court is going to impose a mandatory cost of $210, a $100 attorney's fee, a $300 fine, reduced oversight fees of $20 a month, for a total of $240, no assessment fee, a total fines, costs, and fees, $850. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall submit to random urinalysis once a month. Submit to a mental health evaluation. Pay any outstanding tickets you have with 36th District Court. And I don't see that on here. That's not even on here. All right, and 6 sessions of parenting classes. Of course, Ms. Cummings is eligible for early district. Where's Ms. Cummings? I was looking down and she's gone. And I don't know what point she left because I've been looking down writing. All right, we'll come back to that. I'm ready on Bentley.
Ready, Your Honor.
This is case number 174560801. The people of the state of Michigan versus Shatanya Renee Bentley. The defendant is charged with assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of
Yes, Your Honor. Brandon Bird on behalf of Shatanya Bentley, my client, waives the right to the formal reading and will stand mute. Ms. Bentley, please unmute yourself and state your full name for the record.
Shatanya Bentley.
Please state your full name for the record.
Shatanya Bentley.
Please state your full name for the record.
Shatanya Renee Bentley.
Today is the date set for an arraignment on a bench warrant. Ms. Bentley is actually supposed to be under the court supervision for probation. And I'm looking at the first sheet of the register of action, and she has posted bond at least 4 or 5 times. That means she has capias on this case at least 5 times. She has failed to appear at least 5 times. Because had she appeared, she would have never even had to meet me. And I'm struggling with her having her hand under that chin, Mr. Byrd. Now, I don't know what the conversation was in the breakout room, but what I'm struggling with is the casual nature that Ms. Bentley is appearing in my courtroom. That's what I'm struggling with. And what I know for sure is that if she was present in person, standing in front of me at that podium, I wouldn't have these issues about her being in the bed. I wouldn't have these issues about her having her hand up on her chin. None of that, because she would be standing in front of me at this podium the way it was prior to March of 2020. Now, the world has gone back to normal, or what they say is normal. And court is open. Court is open for business. In fact, there are 2 people sitting in my courtroom right now, waiting for their case to be heard. There could be 3. There could be 3. I'm not going to be disrespected on this Zoom. My job is not going to be minimized and casualized on Zoom. We are in court. We are in court. Court is in session. This is the session of the court. Okay, so she has failed to appear at least 5 times. It appears from the register of action that she was sentenced in 2018. In 2018, I think I was doing the felony docket for the auxiliary judge docket. What I know for sure is I wasn't doing this docket. And she was sentenced. She had to be, well, I'm sorry, she was scheduled for sentence. She had to be re-referred. Even before she was sentenced, she had to be re-referred for a pre-sentence investigation. That means she didn't show up. She was supposed to be discharged in May of 2019. I didn't get on the docket until March of 2020. Since that time of her sentencing, she's capious at least 4 times. At least 4 times she's failed to appear. Since she was sentenced and placed on probation by this court, she failed to appear at least 4 times. Okay. Mr. Byrd, what you want me to do?
Your Honor, respectfully, if we could set her for a review date. My client is here today. She did pay one.
I'm doing a review now. She didn't do anything. She failed to appear. She wanted to show up. That's the review.
Respectfully, Your Honor, my client did pay her bond fee and showed up on her own volition today.
That's
I do
$10. She paid $10 because that's how generous and merciful I am. She paid $10. Go ahead, I'm listening.
And we thank you for that, Your Honor. We do thank you for that. And actually $10 is a lot of money for my client. She indicates to us, even though she works, she still is struggling a little bit. What she does have left for probation, she indicated to me, was that she had to pay the payments, and unfortunately, she has been unable to pay. She has been trying to get herself together. She is working. and does want to put this matter behind her. I believe that she understands that it's been years that went past, also, as this court sees. Yeah, it's not only a burden to this court, but it's also a burden on her, and a burden that she wants to get over. She could have just not shown up and not paid the $10 at all, which I'm not saying that would help the situation at all, but she did. She chose to try to put this matter behind her. She chose to try and come on her own, and
But you know, it don't matter to me if she paid $10 now, because I mean, it does a body good sometimes if you get stopped at stop sign. Get stopped at, you go through the yellow light, a little too late and you get stopped and then the police arrest you. So karma is something else. It comes back around. She could keep running and keep running. She could keep running until she can't run. And when she get caught at the most inconvenient time. So she could have just kept on running and waited till the most inconvenient time. But she was on her way to a graduation, a wedding, a big event, something, and then they arrest her. So that's what karma will do to you. So she didn't do me no favors by showing up. And she showed up like she's doing me a favor. Telling me about she had to take a nap. Telling me about how she overslept. Telling me about why she in the bed. Tell it like she doing me a favor. Miss Bentley isn't doing me any favor. I don't have a warrant for my arrest. I don't have a case pending. I did not plead guilty to assault and battery. I wasn't found guilty of assault and battery. So Miss Bentley is coming on here like she's doing me a favor. We can end it now. She never has to deal with me again until she presents herself in jail. We could take care of it like right now. We could literally be done with this because Judge Archer gave her probation, which was the alternative to jail. And then she keep, showing up and going away and showing up as if that's, doing us a favor. It's not. We already gave her an opportunity to get the alternative to jail. Sometimes, people just need to go ahead and get it over with. It's a 93-day misdemeanor. Next thing you know, you look up, she done missed the whole winter. She don't have to deal with the rain, the snow, none of that. She don't have to shovel nothing. And by the time she get out of the Wayne County Jail, the spring is here. And now the flowers blooming. So we can do that. She picked a good time to turn herself in. Then when the snowstorm comes, she in jail. You don't have to worry about none of that. But what I'm not going to do is tolerate Miss Bentley coming here like she's doing me a favor, because she's not. And I'm not going to tolerate Miss Bentley coming on here like this some casual thing that we do. Because if it was casual, I wouldn't have wore a robe. I wouldn't have put on these pearls. I wouldn't have put on the dress that's underneath the robe. If it was casual, you see what I'm saying? I would have showed up just in my jeans, kicking it. None of this. I wouldn't have these flags behind me. None of that. I wouldn't have none of that because it would be casual. But every time I read the court rules, I don't read anything in there that says that my job is casual. When that young man left across that bench and tackled that judge the other day, nothing about that said that my job is casual. Everything about that said, even when you're dealing with a misdemeanor, your safety is at risk. That's what happened. So she needs to change her attitude, asking me for an extension for a review. No, the review is she has violated her probation. The review is she keeps not showing up. The review is she's ready to go to jail. But since she has such a great advocate, he just talked to me so nice all the time, even though your other client didn't do nothing. I just want you to know that other client didn't do nothing. But I'm never going to bring that into this new client situation. Because what's good for Miss Bentley is that I'm not gonna treat Miss Bentley the way she treated me. I'm not gonna treat her with such a casual way, the way she treated me. What's good for Miss Bentley is that despite all the time she has failed to show up, she has a judge that just literally believes in grace and mercy. Despite her failures and lack of respect for the authority of the court, I'm gonna give her one more time, and I'm gonna guarantee you this, that if I'm the judge, that if I'm breathing, that if I'm still on this bench, and she misses another anything, if she miss another review, if she miss another probation meeting with her probation officer, if she miss anything, I can guarantee you that Grace and Mercy gonna pack their bags, they gonna pack up their little overnight thing, and they gonna leave the room. They gonna say, we're not even here no more, because she taking us for granted. They gonna leave the relationship, because clearly it's a one-sided relationship that she's having with Grace and Mercy. And unlike some other places, in Judge Bryant's courtroom, Grace and Mercy, they do leave. They pack up, they take vacations, they go away, and they're not in the room when people keep missing court and keep asking for me to extend grace and mercy, and they put no skin in the game. And then come on here and treat me like I'm some little casual dating relationship. No, I'm not. And we ain't, no. I'm gonna refuse to be. I'm gonna refuse to be. And I want her to open up her eyes, because I'm gonna accuse her of being asleep. And then I'm also gonna make her come in person. All right. Okay, I don't know if Mrs. Giatti remembers her, but it looked like the only thing she's been doing in 2023 is posting bonds and then not coming. So that's what it looked like she's just been doing. But I'm gonna give her 30 days to square up with Mrs. Giatti. Within this 30 days, she needs to see her probation officer, and just so that we're all clear, that $450 bond that she posted, as well as the $50 that she posted, as well as the other $10 that she posted, it's all been revoked. It's been mailed to the state, and it cannot be applied because she keeps failing to appear. So if she had appeared when she paid that $450, it would have been applied to her fines, costs, and fees. We wouldn't have had to send it to the state after 6 months. So we held it for 6 months waiting on her to come, and she didn't come. Okay, let's give her May the 10th. And that's gonna be in person at 10:02. May 10th in person at 10:02. That's in person, 36th District Court. And before that hearing, she is going to meet with Mrs. Giatti. She is going to find out if she ever did any anger management, community service, victims impact panel. Why she have to do the victims impact panel? I don't know, she might have had a drinking problem. The order is what it is, and it didn't come from me. It came from my colleague, and it's gonna stand. It's gonna stand. It's going to stand, okay? So she needs to find out from Ms. Giatti what she needs to do, and and then it'll be all right. May 10th, in person at 10:02. Anything further? Do we have a current address and phone number?
I do, Your Honor, and I'll put it in the chat to the court.
All right, then we're all set. Ms. Bentley. Have a great day and stay safe.
Thank you, Your Honor.
Ms. Steve said, Ms. Cummings getting ready to have to come in person.
So she says, it's not letting me join back.
It is. She just ain't joining back. It's letting her join back just like anybody else that's joining back. She just not joining back. All right.
Okay.
Are we ready on new?
Ready with Mr. New, Your Honor.
All right, Mr. New, step up to the podium. Mr. New, just stand right there. Just stay right there. Stay right there. All right, these are case numbers 234453901 and 234503601. The people of the state of Michigan versus Richard Allen New. The defendant is charged in each case with 1 count of assault or assault and battery, and today is the date set for each case for final pretrial conferences. Appearances, please.
For the record, Your Honor, Christina over there on behalf of.
Janice Stevenson appearing on behalf of Mr. Richard Allen New. Mr. New, sir, please say your full name.
My full name is Richard Allen New.
Thank you, sir. Today is the date set for final pretrial conferences. Ms. Stevenson, how are we proceeding?
So, Your Honor, I'm sorry, Mr. New, just 1 second. So, Your Honor, with regard to the case and thing in 539, I'm going to move for dismissal for the complainant's failure to appear in that matter. In that, I believe the complainant's presence was required.
Oh, yeah, can y'all hold up? I mean, can you put a note or something on the door? Yeah, yes, yeah. Keep. Okay, Ms. Stevenson.
I believe the complainant's presence was required for November 6th, Your Honor. And I don't know that the complainant was here. And all, to be candid with the court, Mr. New was not here either, but because the complainant was required to be present, and I don't believe was, I would move for dismissal of that matter.
What did Judge Baltimore say about the fact that the complainant didn't come? I said it most likely will be dismissed, and Judge Baltimore must have said, no, he wasn't going to dismiss it.
So if I make I have different notes, and my notes reflect that there's a final pretrial held on November 6th, and the complainant witness appeared, but the defendant did not, and then that's when the court issued for both of the cases where the complainant witness is the same, and the final was $1,000.
I don't know, and I don't know how it got on my docket today at 9:05. I wasn't here on November 6th. And so I'm not going back to do anything as it relates to November 6th because I wasn't here.
In that the people's information is the complainant was present on November 6th. Mr. New will continue his plea of not guilty, and we'd ask that both matters be scheduled for jury trial, Your Honor.
Okay, and then I do want the record to be clear that even if the people's notes reflected that no witness showed up on November 6th, I was still going to deny defense counsel's motion. And I'm gonna just let you all know, I'm never going to rule on an issue that was handled in my absence. So whatever occurs in my absence, that's what it is. And so whatever issues that you all have when I'm not here, whatever the judge's decision is, that's the judge's decision until I come back, and then I'll address the issue that's going on while I'm here. So that's all I just want to make that clear. But nonetheless, court is going to continue a not guilty plea on behalf of Mr. New, and I'm going to set the matter for jury trial. And, oh, I did that case.
Oh, you did.
It's.
Yeah.
All right, I'm gonna set the matter for jury trial, and Mr. New's jury trial is going to be. I know, how many, I can't find my other book. That's the plan again. Okay. I think I was at least, I know I was into May. Tell me April 16th, how many? Oh, yeah, because on April 22nd, I have 4.
April 22nd, Sherry Hart, jury trial.
You saying I just had 1?
On April 16th.
No, April 22nd.
Oh, I'm sorry.
I gotta figure out why I only had 1 on the 16th.
That's 4.
Yeah, okay, so then, and then on April 30th, I have 3. I should have 3.
Yep.
Okay, what about, May 6th?
Oh, 1, 2, 3, 4, 5. 5 scheduled on the day.
Okay, May 6th. Okay. And what about, May 14th?
4.
And what about May 20th?
1.
All right, so we're on May 20th. Court is going to continue a not guilty plea on behalf of Mr. New and set his matters for jury trial, May 20th. At 10:30, and you said I have 1 already on there?
20. Yes, just 1.
What's the name?
William Jackson.
And who's the lawyer?
Ms. Stevenson.
And when is the final free trial?
April 19th.
And, what's the charge?
Andy, saw that.
Okay, so Mr. New will be the second in priority. And I'm gonna set his final pretrial conference for April 19th as well. Final pretrial conference, April 19th at 9:10. Anything further? No, thank you.
Nothing on behalf of Mr. New. Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe. Wasn't that the victim's advocate?
Yes, sir.
Oh. Mr. New, you're all set, until April the 19th, okay?
Could I say something?
It depends on what you want to say.
He keep making gun threats at me all the time.
Ms. Stevenson, your client needs to speak with you.
I come in the courtroom, Judge.
All right.
Oh, no.
I'm sorry?
I think he said he wanted to say something to you. Are you letting him say
No,
something?
he already started saying what he's saying, and I said he needs to talk to you.
Okay, so are we finished for the record?
No, not based on what he said.
I agree with that.
So,
I already talked to Mr. New about this.
okay.
I'm stand right here. Okay.
So, Mr. New understands and continues to abide by this court's no contact condition, but he has advised me as he, started to advise the court just now that the complaining witness continues to engage in a pattern of harassment against Mr. New. And he would just, like the court to be aware of that and would like for that to stop.
So Judge, this is not here. I don't have any information regarding the allegations. However, the complaint is clear that no contact order is mutual and we will try their best to try to not.
Okay, well, it sounds like they don't know. Sound like, and I'm gonna just make a clear record. Mr. New said the person making gun threats toward him. That's what he said before Ms. Stevenson came. Now, I don't know what proof he has of any gun threats toward him, but tell the plaintiff witness to stop talking to Mr. New. And Mr. New, don't you talk to the plaintiff witness. Are they neighbors?
They are neighbors.
Okay, I mean, I don't understand when neighbors can't get along. Tell, I was getting ready, but I was getting ready to tell. I was getting ready to tell Mr. New, tell the plaintiff witness, but that ain't, that was not what I was saying. Ms. Ritter, tell your witness I said they better not be communicating with Mr. New, and they better not be making threats against Mr. New, or else I'm gonna put them in jail. Just tell them I said that. Yeah, and tell them I said, ain't nobody scared of them. I don't know, Mr. New might be scared. But tell them I said, I'm not scared. They need to stop talking to Mr. New, if they are. If they are, I don't know their side of the story. So Mr. New, just make sure if you know, if, Mr. New can't talk while I'm talking, what's going on? So, in addition, Mr. New just wants the court to know, that in addition to the information he's already, the violation of no contact condition that he's already stated, he's also indicated that the complaining witnesses are spraying Roundup, weed killer, grass killer on his property. And he would like for that to stop. Hey, well, we already addressed it. We already addressed that they're not to have any contact. We already addressed it. Anything further? If I could just have 1 second. Okay, I'm not gonna address every little individual issue. I've already said that they cannot have any contact with Mr. New, and if they do, they're subject to going to jail. I've already said that. That is clear on that. She doesn't want to talk about everything that you're saying that they're doing. She just told the prosecutor to let them know they're not supposed to have any contact. And Ms. Stevenson, we're not also gonna let you stand there and repeat what I exactly just said. We thank the court, Your Honor. All right. Okay. All right. Okay. Thank you, Your Honor. All right. You're welcome. Okay. That is for 3 trials. I don't know. No, we're still in the sentencing. She came back. Okay. And then.
Excuse me, permission to speak.
Why is somebody making in the? Yeah, Mr. Bird, yes.
Is there any way we could readdress the tether for Cara Davis? I know she missed a lot of court dates, but is there any way possible we could potentially raise her bond?
No, she better present herself for that tether.
Gotcha. All right, thank you, Your Honor.
All right. Tell Ms. Stevenson I'm ready on Cummings. You need to do a lot of stuff before the trial. Well, go tell your sister counsel to come in here and come on. I'm ready. Yes, she does. I wish he was in here now so he could see that. Yeah. Oh, I'm gonna take a picture of it. Somebody, who is that at the door? I don't know. I wish I would too. Yeah. Okay, I mean, I'm not sure what's going on at my door, but I need it to not go on.
Check that. I know there's 2 officers.
Okay, go tell your sister council. Can somebody, oh, there go Miss Stevenson right here. Okay. I'm ready to recall, Jessica Cummings. What did I do with it?
Wait, because I'm on the record.
All right, this is recalling case number 19446000601. All right, I'm gonna start all the way over with Simpson, because I don't know at what point Ms. Cummings is no longer there, but appearances, please.
For the record, Your Honor, Christina Romero, we have a meeting.
Again, for the record, Janice Stevenson appearing on behalf of Jessica Cummings. Ms. Cummings, ma'am, please unmute and again say your full name.
Jessica Teresa Cummings.
All right, so a court is going to impose the following sentence: 12 months probation. Oh, I did want to address, was there any objection to a delayed sentence?
Judge, so if Ms. Cummings is eligible, the people have any objections to the sentence. There wasn't a PSI, so.
I think she's up. We'll see. It turns out she's not in. We'll change it. Okay. Court is gonna sentence Ms. Cummings pursuant to 771.1 if eligible. And with a final review date of January 9, 2025, with a first review of May 9, 2024 at 1:30 p.m. The court imposes $210 mandatory cost, $100 attorney's fee, a $300 fine, and a reduced oversight fees of $20 a month for a total of $240. I'm sorry. Supervision fees total $240. And then I also forgot to actually add $10 a month your analysis fee for $120. So the total fines, costs, and fees is $970. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. Submit to your analysis once a month, and if I'm satisfied with the results, I will discontinue that at the first review. Submit to a mental health evaluation. Pay any outstanding, because I need everybody that's gonna stay in, be in, and stay out, be out, because that door is disrupting me. All right, pay all outstanding tickets with 36th District Court, 6 parenting classes, no assaultive contact with the complaining witness, and I think that's it. Anything further?
Nothing for the group, Judge. Thank you.
Nothing on behalf of Ms. Cummings. Thank you very much, Your Honor.
All right, Ms. Cummings, we're gonna mail you a copy of the order of dismiss, of the order of probation, and if you complete the probation successfully, then it can be dismissed and removed from the record after 6 months, okay?
Okay.
All right, then you're all set. Have a great day, stay safe. All right. We're in 10-minute recess. And I guess, I'm not really interested in trying to find out. Khadijah, there's no Khadijah on my docket.
Ask you a quick question.
Sure.
Do you want me to start including words? Okay, all right.
You never was looking at me.
I mean, I did last time, I just wanted to make sure you wanted it.
Yes.
Just something. Okay. Got it.
Okay, we're all set. We're in recess until 10 minutes.
Thank you, Your Honor. And Good day to this honorable court if I don't see you all again.
All right, thank you, Mr. Bird.
Bye, Brando.
Bye-bye.
Y'all see Mr. Bird demoted me from wise and honorable. I'm just messing with you, Mr. Bird. I'm just messing with you, Mr. Bird. I'm just messing with you.
You still wise and honorable, Your Honor.
All right. Ms. Stevenson, if you want to, you can try to see who could ease his iPhone in, but I'm going on break.
I can't right now.
234442101, the people of the state of Michigan versus Bonita Devon Brooks, defendant is charged with 1 count of assault or assault and battery, and today is the date set for trial. Appearances.
For the record, John, please sit around on behalf of the people, number 83505. I have my OIC present courtroom who is standing behind me to my right.
Yes.
Second, Campbell Smith.
All right.
And then, Judge, there are 2 other individuals seated in the back of the courtroom. They are actually our recent advocates from our office, and they just want to join and watch if that's okay.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Bonita Brooks. Ms. Brooks, may I please tell the judge your full name?
Bonita Devon Brooks. And you today is the day set for trial. Are the people ready to proceed?
Just today is the day time set for trial, and people are ready to proceed.
And let me, is the defense ready to proceed?
Defense is ready to proceed, Your Honor.
Procedurally, today was the date set for jury trial, but at the last proceeding, we put the waiver on the record, correct?
Correct.
Yes, Your
All
Honor.
right, and then what I meant to do and what I want to start doing, if I can remember the ones that were changed, once they come in person, can we have them actually fill out the waiver?
Okay,
You know, let's start back filling out. the
Okay.
waiver. Okay, all right, any preliminary matters before we begin?
Yes, Judge, the people are motioning for order of sequestration with the exception of my OIC, who is present in the courtroom, and the people have advised the other witnesses not to watch any court proceedings or the trial.
All right, any objection?
I have no objection, Your Honor. And I would concur in the motion for sequestration. Your Honor, I do have one individual who was present, at the time of the incident. I don't anticipate calling her, but I would like an opportunity to make sure she doesn't watch.
Okay, you may.
Just in case.
How many witnesses, people anticipate?
People have 4 witnesses, we anticipate calling 3.
Excuse me.
All right. Got it. Okay, I won't make a comment to that. Ms. Brooks, you may be seated. Yes, and you as well, officer. And I'm sorry, what's your rank, is it? Detective, okay, thank you.
Yes, sir.
I cannot. That's my calendar from the calendar that I was doing was 23-24. And I was trying to convert it over to this. I'm gonna have to, maybe it's in my car, it's or something. I'm gonna have to look, I can't find it. Oh, was Mr. Camacho, see on probation? Oh, no, right, so it's just closed.
Yeah.
Okay,
With improvements.
yeah, close with it.
Okay.
Oh, I'm sorry. Okay, any other preliminary matters before we begin?
Nothing from the bench, Your Honor.
All right, any opening statement on behalf of the people?
Yes, very briefly, Your Honor. So, Your Honor, this case is actually not in the court. It is a case that stems between 2 neighbors. And the people are not disputing that there is an ongoing issue with these 2 neighbors that includes the defendant, Bonita Brooks, and the second witness, Ms. Watkins. However, Your Honor, we are here today because on a particular day, March 27th of 2023, Ms. Watkins was across the street from her house, and Ms. Bonita Brooks, who was the neighbor of Ms. Watkins, was standing on her porch with a gun in her waistband, threatening to do something to Ms. Watkins. Now, Ms. Watkins will testify that she was across the street because she participates in doing a pickup and drop off for her neighbor's child to a mentoring program. She testified that on this particular day, she was waiting in her neighbor Lakita Triplett's driveway, when the court was testimony from Ms. Triplett, that she was there to pick up Ms. Triplett's son for this mentor program. The court record testimony from Ms. Watkins that while she was sitting in the driveway, Ms. Brooks and her daughter were in the driveway, yelling, threatening her from across the street. And at that time, she observed Ms. Brooks on the porch with a gun in her waistband, threatening her. Now, Judge, the people do have exhibits that they intend to admit into evidence, and one of those exhibits are the People's Exhibits 1, which shows Ms. Brooks on the porch with a gun in her waistband, yelling threats to Ms. Watkins moving across the street. Your Honor, the court will also hear testimony from again Ms. Lakita Triplett, who will testify what she observed when her son FaceTimes her the day this incident occurred, who was very scared and was telling his mother that Ms. Brooks was across the street with his gun. She will testify as to what she observed on FaceTime and what she observed after she had to leave work and hurry up and come home while this incident was occurring. Your Honor, the court will also hear from the responding officers, Officer Barron, and the people intend to call Officer, or anticipate to call Officer Peterson, who was his partner at the time. And the court will hear from the officers on what they observed when they came to the location of this incident and what transpired. After the court takes in that evidence, the testimony from the witnesses, Your Honor, the people are hoping that this court returns the guilty verdict of count 1 assault. Thank you.
Will there be any opening statement on behalf of the defense at this time?
Yes, Your Honor, we concur with the people that the court is not new to these proceedings. That we did have a bond violation hearing. The court has already been made aware of the fact that there is an ongoing dispute between these parties. I mean, the evidence is going to show that it's been going on for a number of years, and that unfortunately it is still going on. I'm asking the court, based upon what people just indicated about this gun, to take into consideration the fact that Ms. Brooks is not charged with weapons brandishing. She's not charged with any felonious assault, and that's because there was no gun. That we believe the evidence is going to show that that which was taken into custody, that which was placed on evidence, was pepper spray. That the police did search Ms. Brooks' home with her consent shortly after this incident was to have taken place, and they did not find any gun because there was no gun. We're not going to dispute that there's going to be some video evidence. It looks like there's a weapon in Ms. Brooks' waistband, but there's no gun that's recovered. She denied having a gun. The police didn't find a gun. There was no gun there. There's an ongoing dispute between these neighbors, unfortunately, that's been going on for years. And we're going to ask at the end of the court find Ms. Brooks not guilty, because we don't believe that the people are going to be able to show beyond a reasonable doubt any unconsented contact or any threat of any unconsented contact against the complaining witness initiated by the leader.
Okay. Ms. Ritter, call her first witness.
Thank you, Your Honor. At this time, we call Ms. Williams about to stand. Okay, she's sitting in court on 336.
Yes, he does. Oh, just for her. Just for the, so she was here. Yeah. Step towards me. Raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, you're right. All right, you may be seated. Tell me your name, I'm sorry. Ms. Watkins, just make sure that you keep your voice up. I do see that you have on a mask, and that's fine, of course, you can keep it on. The mic in front of you, it moves, it moves like this, and the base of the mic moves. Just make sure that we can hear you, which I don't necessarily think I'll have a problem hearing you, but just make sure that your voice doesn't trail off, okay? Okay, all right, Ms. Ritter?
Thank you, Judge. Good morning, Ms. Watkins.
Good morning.
Ms. Watkins, can you state your name for the court again?
This is Gwendolyn Jean Watkins.
Thank you. And Ms. Watkins, I want to take you back to March 27th of 2023. Do you recall that?
Yes,
And were you near an address on Stout Street?
yes,
And is that the city of Detroit?
yes,
And is that within the county of Wayne?
yes.
Okay, and can you start off by telling the court what you were doing at that address on Stout?
I was picking up my neighbor's son, Kyra, for his mentor program.
Okay, so when you say your neighbor, what kind of neighbor is this?
My neighbor that lives across the street.
Okay, so you live across the street from this location?
Yes,
Okay, and do you usually pick up your neighbor's son for a mentoring program?
yes, I pick him up every Monday.
Okay, and what happened while you were at the location picking up your neighbor's son?
I backed into the driveway. I was talking to my daughter on the phone, and I happened to look up and see the commotion.
And when you said commotion, explain that to the court.
I seen Lauren Smith. I don't know her boyfriend's name. It was her boyfriend, and it was Christopher Brooks standing at the end of the driveway.
Okay, who was Lauren Smith?
Lauren Smith is Bonita Brooks' daughter.
Okay, and where was she standing?
She was standing at the end of her driveway.
Okay, and where's her house adjacent to yours?
It's right next door.
Okay, so Ms. Brooks and her daughter is in the house next door to your house,
Yes,
and you are parked across the street at the neighbor's house.
yes,
Okay, and can you see directly where Ms. Smith is standing?
yes.
Okay, so where is Ms. Smith from where you are?
Right in front.
So right across the street?
Mhm.
Okay,
Is that a yes or no?
Yes.
Just try not to say.
Okay.
okay. And what happens when you see Ms. Smith in the driveway?
They were just throwing hand gestures.
Who is that?
Her and her boyfriend and Christopher Brooks.
Okay, who is Christopher Brooks?
That's Bonita Brooks' brother.
Okay, so how many people do you see where these individuals are?
It was 3 at the time.
Okay, so you testified that it was Lauren Smith, and you testified it was Christopher Brooks, and you testified it was a third person. Who was that?
Lauren Smith's boyfriend.
Okay, so you just see these 3 people at this time?
Yes.
And where are they all standing?
They're standing in the driveway.
Okay, and you said they throw up hand gestures. Do you recall what hand gestures they threw up?
I really wasn't paying attention to them at first.
Okay, and so what happens after they throw up these hand gestures?
That's when I seen Ms. Brooks come out of her front door and she goes to her car.
Okay, where's her car located?
Her car is parked right behind them in her driveway.
Okay, and the person you're referring to as Ms. Brooks, you see that person in the courtroom?
Yes.
Can you point that person out and tell me what they're wearing here?
She's wearing a blue sweater and blue jeans.
Anything else?
Yeah. As far as her,
Can you point out anything else that she's wearing?
she has a black hat with a fur on top of it. She has braids in her hair, gold earrings.
May the record reflect the identification of the defendant as Bonita Brooks?
Okay,
Yes, ma'am.
I know, I believe I know what you're talking about, but this, I don't see really anybody with blue on except you. So I can't see.
She did point to her nose, but
Okay, where is she sitting? Is she sitting next to somebody or by herself?
She's sitting next to, the lady in the brown, light brown and, leather shirt.
Record reflect the identification of the.
thank you. Well, so where do you see Ms. Brooks go to again? I'm sorry.
Ms. Brooks came out of her front door. She went to her car.
Okay, and can you again tell the court where her car was?
Her car was parked right behind Lauren Smith and the boyfriend and the brother.
Okay, and what happens after Ms. Brooks goes to her car?
She
Or what
walks,
you can see?
she walks directly to her car. She comes back out with the gun and she pointed directly at me.
Okay, and at that point, what do you do?
I told my kids to get down on the floor, my granddaughters, and I immediately called the police
And where was your granddaughters?
in the backseat of my truck.
Okay, and do you recall, if you can, do you recall how this gun looked?
It was black.
Okay, was it a short gun, long gun?
It was a short handgun.
Okay, and if any, did you hear anything, that Ms. Brooks said while she pointed the gun?
No, I was sitting in my car. When I
Okay,
called the police, I started recording.
okay, so at what point did you start recording Ms. Brooks?
When I called the police.
Okay, and what happened after you started to record Ms. Brooks?
She was livid. There was just all over the place. The daughter tried to run across the street and her boyfriend caught her.
And what, I'm sorry. I didn't say anything. Oh, I'm sorry. Where was Ms. Brooks at this point?
She was at that time, she was still in the driveway with them.
Okay, and do you know how long you recorded this interaction?
I recorded it as long as I was on the phone with the police.
Okay. Can I have one moment, Judge? You may. You may.
Ms. Ritter, just for your information, you're a witness. Caleb Tutts. Defendant's name is Caleb Tutts. You're a witness. You're January. And they were supposed to be here.
November 28th.
I just want you to know that's who that computer was. Wait.
Okay, thank you. Ms. Watkins, can you see what's on the screen?
Yes.
Okay, do you recognize what's on the screen?
Yes.
What do you recognize on the screen?
My house and, Lauren Smith and her boyfriend standing right there in this, Brooks driveway.
Okay, and what's on the screen is a still shot, but what is it on the screen? What is it a still shot of?
It's a still shot of, Miss Brooks' daughter and the, boyfriend.
Okay, and do you recognize this to be the video that you recorded?
Well, I started actually recording, yes.
Do you recognize this to be the video that you recorded?
Yes.
Okay, and from your recollection, has this video been changed, altered, or depicted in any kind of way?
No.
And was this the same video that you turned over to the police?
Yes.
Okay, Judge, at this time, the people move to the exhibit 1, is there any objection?
I don't have any objection. Your Honor, may I approach with the people?
Sure.
Thank you.
In the front, I don't.
Yeah, that's fine.
Oh, we gotta wait. Okay. It's gonna be brief.
Yes,
Okay,
absolutely.
let's go.
That's why I approached.
Okay. Cause you ain't want to get right.
All right.
And I can't see, so, cause it's real gap. Okay. Okay. Ms. Ritter. Oh, Ms. Dixon, any objection?
No objection.
All right, people's proposed exhibit 1 is admitted as people's exhibit 1.
Thank you, Judge. At this time, if people would like to publish people's exhibit 1 to evidence. I'm sorry, to the court.
You may.
Thank you. And for the record, the people are playing the video at 0 seconds.
I'm sorry. Yes, I'm sitting inside my truck looking at them. Yes. Okay, I'm waiting for my nephew. Do you understand what I'm saying? I'm waiting for my nephew. No, her daughter is coming towards my vehicle. She is standing on the porch. The one with the gun is standing on the porch. My name is Gwendolyn Watkins. Thank you.
For the record, Judge, the video is at the end at 1 minute and 5 seconds, and people stop sharing the screen. So after you recorded that video, Ms. Watkins, what happened next?
I waited for the fireman to come outside. And he got in my car, and I waited for the police to get there, when they didn't even get there for 2 hours.
Okay, now let's go back just a minute. So while this is happening, you're still sitting in the driveway waiting for the police?
Well, yes, when I called them.
So you're still sitting in the driveway that you're in?
Yes.
Okay, and why were you still sitting there waiting for the police?
Because the timer is not a normal 18-year-old, he has ADHD.
Okay.
And I didn't want to just pull off. And he hadn't got outside yet.
Okay, so you were waiting on him to come outside?
Yes.
Okay, and at some point, did the police arrive?
2 hours later.
Okay, and did you have an opportunity to speak with the police?
Yes.
Okay, and did you give a statement to the police about this incident?
Yes, I did.
Okay. May I have one moment, Mr. Ray? One more question, Ms. Watkins. While you were waiting for the police, did anyone else arrive to the scene of the incident?
Lakita Triplet, which is the Kyron's mother.
Okay, do you know how long, I'm sorry, do you know how long it took for her to get to the location?
I see about 25 to 30 minutes.
Okay. I have no further questions, Judge.
So you want to start. Okay.
Right now, there's a lot of people. Cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Watkins.
It's this morning.
Good morning, Ms. Watkins.
Good
I'm so
morning.
used to working for this.
Oh, yeah, but not yet, not yet. We still have almost 45 minutes.
Cool. All right. Okay, so Ms. Watkins, can you tell us, how much time passed? You testified that you saw Ms. Brooks go to her car to get a handgun?
Yes, ma'am.
Okay, and then the video shows Ms. Brooks on her front porch.
That's when I was on the phone, when she was standing at the driveway.
Okay.
I don't have video of that because I was talking on the phone with my daughter.
Oh, I understand. Okay, all right. Okay, so, is there anything that's happening before? Okay, let me ask you like this. Do you share that driveway? Or is your house adjacent to that driveway where the two individuals are standing?
No, I do not share driveway. My driveway sits on the other side of my home.
Okay, so is that driveway between Ms. Brooks' house and your house?
Yes.
Okay, all right. So, when you pull out of your driveway to go over to your neighbor's driveway, do you see anybody at Ms. Brooks' house?
I didn't pull out my driveway.
Oh, okay. So where were you? I'm sorry. So where were you before you went to your neighbor's house?
I just picked up my grandchildren from school.
Okay, so you had not been at home?
No,
Okay, so when you first pull into into your neighbor's driveway, do you see anybody over at Ms. Brooks' house?
no.
Okay, at what point do you notice somebody over at Ms. Brooks' house?
As soon as I seen her daughter and the young man standing at the end of the driveway.
Okay,
And I still wasn't paying attention to them because I was on the phone with my daughter,
okay,
waiting on my nephew to come out the house.
okay, all right, so then you back into your
Yes.
neighbor's driveway, and then you see Ms. Brooks' daughter
Yes,
and her boyfriend in the driveway.
and the brother, Christopher Brooks.
Okay, all right, is there any conversation between you and the three of them?
Absolutely not.
Do you hear them saying anything?
I didn't hear the muffles until Ms. Brooks came out.
You didn't hear what?
The commotion until Ms. Brooks came out of her home.
Okay, all right, so you're not saying anything to them?
No.
And they're not saying anything
No.
to you? Okay, all right, so, how much time passes between, when you kind of, you're seeing something happen in the driveway and then Ms. Brooks is on her driveway, how much time?
I say about 10 minutes.
Ma'am, you have to let her completely finish her question and then answer. What's your question?
And my question was not clear. I would like to know how much time passes between when you see Ms. Brooks in her driveway, her driveway, getting something out of the car, until the time you see her on her porch.
She entered the porch after she got the gun out of the car.
Okay,
She came out of her front door.
okay,
She walked on the side. She went straight to her van, her SUV.
okay,
That's when she came out and she lifted the gun up. She stood back because she knows that my camera is on the front porch. So
okay,
she stood back and pulled the gun.
okay, and that was while she was in the driveway.
Yes.
And then she goes to her porch.
And then that's when she's still with the commotion. That's when she goes to her porch.
How long does it take her to go from, how much time passes between the driveway and when she got to the porch?
Not even 4 minutes.
4 minutes?
Not even, yes, about 4 minutes.
About 4 minutes. Okay, all right. So how long is she in the driveway with this gun? How long is she in the driveway holding the gun?
I think about 4 or 5 minutes.
And what were you doing?
I was sitting in my truck.
Okay. Okay, and you had children in the car with you?
Yes, I did.
Okay. So why didn't you, was she pointing a gun at you?
Yes, there was no one else there but me.
And you stayed in the driveway?
I stayed in my neighbor's driveway when I called the police.
Okay, and so then she goes on the front porch,
Yes,
and does she still have the gun at that time?
yes, it's in her pocket. She sticks it in her pants at that time.
Okay, did she point it at you anymore?
No, not then.
Okay, all right. Okay, so how long do you stay in the neighbor's driveway?
I stayed there until somebody could come because I had children in my car. My neighbor's son eventually got in my car.
Okay, well, let me ask you this. Okay, so did you leave immediately after your neighbor's son got in the car?
No, I
How
went
long-
for the police.
Okay, how long did you stay in the driveway after your neighbor's son got in the car?
Until my husband arrived and Miss Lakita triplet arrived.
About how long was that?
I say about 25 minutes.
Okay, all right. Okay, and you believe that Ms. Brooks had a weapon that she might have tried to shoot you with?
She pulled out a gun, ma'am.
Okay, but you stayed in the driveway?
Because my neighbor's son he has ADHD.
Okay,
So he's not a normal 18-year-old.
okay,
So he doesn't react real fast. You have to get him to react.
okay,
So he doesn't react real fast.
okay,
So when I was actually calling him when I got off the phone with the police to let him know to stay in the house, but he never answered his phone. He just walked straight on outside.
okay, so
And I did not want to leave him.
okay, but at some point he does come and get in the car.
Yes,
And then he Did you leave right away when he got?
No, I waited for the police.
For about half an hour?
The police never showed up. My husband and Miss Triplet showed up before the police.
Okay, all right. So, so you refer to the individuals in the driveway by name. That was Lauren
Smith, Christopher Brooks, and the boyfriend. I do not know who he is.
Okay, but you believed him to be Lauren's boyfriend?
Yes.
Okay, now how do you know who these individuals are?
I've had problems with my neighbors before.
Okay, all right, so that's how you knew these people's names?
I've had the whole family arrested. That's how I know their names.
Okay, so when did that happen?
Judge, objection.
It goes to our absolute theory of the case, Your Honor. That it
When she had the family arrested, that's, how does that go to the absolute case? In fact, it might be just improper questioning altogether. I don't understand.
So, Your Honor, it's our theory of the case that there is an ongoing dispute.
I already know that it's ongoing, but how is it relevant when she had them arrested? It's not sustained.
Okay, so, how many times had you had them arrested?
Judge, objection. With family?
Yes, ma'am.
Each person, Ms. Brooks been arrested maybe 4 times. The son has been arrested once, and I had to have the husband arrested. And he's been arrested once.
Okay, all right. Has that been going on a long time?
Since I've lived there.
How long have you lived there?
I bought my house in 2017.
Okay. Okay, have the neighbors ever called the police on you?
No.
Okay. Do you recall the police ever questioning you about any complaints?
I've never had no contact with the police.
You have to let her finish her question. Okay, what is your question?
I asked her if the neighbors had ever called the police on her, and I think she.
That's not true. I mean, that's not, I didn't even say that's not true. I'm sorry. You didn't say, that's not what you said. You said, did you remember answering? You already asked her, did they call the police on her? She said no, even though she could have no way of knowing that. There's no way she could ever know if they called police on her, unless, anyway. And then you asked her, did she recall answering something, and she overtalked?
Okay.
So you don't remember? Okay.
Yes,
we'll
the
move on to
police
the
about
next.
some complaints.
What happened?
Asked her, did she answer any questions from the police about any complaint?
Oh, Ms. Ritter says that was your.
Thank you, Ms. Ritter. That's all. Okay, I think that's all I have.
Okay, any redirect?
Very briefly, Judge. So, Ms. Watkins, you testified that you were picking up your nephew. Who are you referring to as your nephew? Miss Lakeisha Church's son. I just called him my nephew because he called me Kiki. Okay, and I think you testified before, I asked you before, but how regularly do you go and pick him up to go see the mentor? I pick him up every Monday. I've been picking him up every Monday for over a year. Okay, and Ms. Stevenson asked you how much time passed between Ms. Brooks getting from the driveway to the porch? Okay, and I'm sorry, what was your answer to that? I said about 5-10 minutes. Not 10 minutes. It was about 4 or 5 minutes. Okay, and during that time, had you already called the police? I was actually on, or as soon as she pulled the gun out and pointed it towards me, I hung up on my daughter and I immediately called the police.
Okay, and so you called the police, and then at what point, if you recall, did you start recording this?
I actually started recording her when I called the police.
Okay. I have no further questions.
Nothing further.
All right, thank you, ma'am. You may step down and you are free to remain in the courtroom if you want to. You can call the next one.
Thank you, Judge. At this time, the people call, the Peter Church to the city. LA, just for her, man.
Step towards me. Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, sir? God?
Yes.
All right, and state your name for it.
You
may put your hand down. Be sure that you've been in the hall waiting for you've been outside of the courtroom. I don't know where it's with your head, but you've been outside of the courtroom waiting to be called as a witness, correct?
Yes.
While you were out of the courtroom waiting to be called as a witness, did you view any part of this trial on the court's live stream?
I did.
Okay. The witnesses thank and thank you for that. May call the next witness.
Thank you, Judge. At this time, people like saw Officer Darren to the stand.
Oh, the officer left out, so you, oh, okay, your OIC will be Officer Mayor. Officer Barron. Stop.
Sorry.
That's right. Go around this way. Hey, Officer Barron, other courtroom the other day. He tall. And he went to the courtroom. Officer Barron. Officer. And, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. I'm sorry. Yes, ma'am.
You may be seen. Officer Barron, you didn't watch the live stream, did you?
No, ma'am.
Oh, you didn't tune in into
I don't even know what that is.
okay, thank you. All right. You don't know what the live stream is?
I'm not technology.
Oh,
I got kids.
Tell him I said show. Hold on. Okay, see, I get easily sidetracked sometimes, Officer. Ms. Ritter, you may proceed, so you don't have to answer my nosy question.
Thank you, Judge. Good morning, Officer Barron. Officer Barron, there's a mic right in front of you, it does move up and down, so just make sure you speak directly to the mic so that the court will take on everything you're saying, and that the court can hear you, okay?
Yes, ma'am.
Thank you. Can you state your full name for the record?
Officer Terrence Barron,
And Officer Barron, where are you employed?
the city Detroit Police Department,
How long have you been employed with the city?
almost 5 years.
Okay, and I want to take you back to March 27th of 2023. Were you working on that day?
Yes, ma'am.
Okay, and do you recall what you were wearing on that day?
I'm sure I was in full uniform. I was out on the street.
Okay, and when you say out on the street, is that patrol?
Yes, ma'am.
Okay, and are you on a bike? Are you in a vehicle?
I was in a fully marked police vehicle.
Okay, can you describe that to the court?
A white Ford Explorer with Detroit Police on the side with a light bar on top. Bush guard.
Okay, and what does patrol consist of?
Police runs, enforcing traffic laws, regular patrol.
Okay, now, do you recall getting a police run to or at near or at 17187 South Street?
Yes, ma'am.
Okay, and is that the city of Detroit?
Yes, ma'am.
And is that within the county of Wayne?
Yes, ma'am.
Okay, and can you start by telling the court what you observed when you came to this run?
I observed a large crowd of people outside.
Okay, now let me go back just a little bit. Do you recall what the run was for? The police run was for?
I believe it was for FA in progress.
Okay, can you explain what FA means?
Felonious assault.
Okay, not that the court doesn't know, I just need to.
Yes, ma'am.
The record should be clear. Thank you. And so, do you remember who you came into contact with first when you came to the scene?
I don't remember which. I believe I talked to the victim first. I'm not 1,000% sure.
Okay, if you recall, do you see who the person your name of the victim is in the courtroom?
Yes, ma'am.
Okay, can you point them out, tell me what they're wearing?
A white shirt. I mean, a blouse, a white blouse.
Okay, can you tell me anything else about that person? Short
blonde hair.
Stop, ma'am, don't do that.
I'm
Don't
sorry,
do that.
short blonde hair. But I mean, I can't see his pants or anything, but
Okay.
short blonde hair.
Judge, may the record reflect identification of the complainant when it's one of the blacks.
The record will reflect, and the record is also going to reflect that Ms. Watts, when you asked him to identify a person that he saw that he thought he talked to, Ms. Watts pulled down her mask so he could see her face, waved at him as to identify herself to him. So the record is going to reflect that while I'm not suggesting that the officer would not have identified her, because he appeared to have started identifying her, she identified herself to him. So the record reflects that. But go ahead, question please.
Thank you, Judge.
I need you not to make any gestures, not to do anything, ma'am. Otherwise, you're gonna jeopardize the case. You may proceed, Ms. Ritter.
I have one moment. Okay, may I proceed?
You may.
Thank you. So Officer Barron, without telling me what was said, do you recall from your knowledge of this police run, what this police run was about?
Yes, ma'am.
Can you explain that to the court, please?
It was an ongoing neighbor dispute, which allegedly led to offender one pointing a gun at the victim one.
Okay, now did you come into contact with this person that you're saying is offender one?
Yes, ma'am.
Okay, do you see that person in the courtroom?
Yes, ma'am.
Okay, can you point them out and tell me what they're wearing or describe this person?
I think that's blue sweater or shirt and a braid, short braid.
Okay, doesn't make the
I
record.
can't tell if that's blue or not. Well, it's blue, I'm sorry.
May the record reflect identification of the defendant, Anita Brooks.
The record should reflect, and I you know, it was,
Purple or blue?
it's something. Okay. Who, are they sitting next to somebody?
Yes,
or
ma'am.
alone?
they're sitting next to somebody, the young lady, she has a hat fire with a little ball on top, she has blue jeans on and black shoes.
Record reflect, the plexiglass is a, I can't see, and it's flares and all of that, so that's why but it could be blue.
Right,
I just
blue or purple.
really can't see, but the record reflect the identification of Ms. Brooks, the person that's seated next to defense counsel and has a ball on top of the hat that's sitting on the table, that's what he identified.
Thank you, Judge. Okay. And, did you notice or observe anything, when you came in contact with Ms. Brooks?
You might be more specific, I'm sorry.
So when you came into contact with her, did you notice anything on her person that's related to this run that you came in contact with?
No, ma'am.
Okay. If any, do you remember anything specifically about Ms. Brooks? Do you recall anything specifically about Ms. Brooks when you came in contact with her?
No, ma'am. Do you have anything specific? I'm sorry, but nothing major comes to mind. I'm sorry.
It's okay. May I have one moment? You may. Okay, let me ask you this, Officer Barron. What happens after you come in contact with Ms. Brooks?
I talked to her, conversation is had, like I said, it's a large group of people, so I guess Maria that's over there. She states.
Say that again.
The defendant, it's a large crowd outside, so we get some more units, it's only me and my partner at that time, yes, ma'am.
Thank you.
So I'm able to, talk to Ms. Brooks, and at that time, there's understanding that she states that she did in fact have a weapon on her.
Who stated that?
Ms. Brooks, she
Okay,
said.
do you recall what type of weapon? I'm sorry.
Yes, ma'am. She said it wasn't a gun, it was a pepper ball gun or pepper gun or something, pepper spray gun.
Do you recall seeing what she was referring to?
It was inside of the house at the time.
Okay, did you ever see this pepper spray ball gun?
Yes, ma'am. It was recovered at the location. Ms. Brooks showed us where it was at, where she
Okay.
put it.
Can you describe, if you recall, how this pepper spray gun was?
It was, man, looked like a little device, not this big. That shot out pepper spray, looked like a little spot for the pepper spray to go. I mean, I don't know, to be honest.
Okay, did it resemble a gun?
I can see it being taken as a gun from a distance. Yes, ma'am.
Okay, so from your experience and your training, would it resemble a gun to you?
Yes, ma'am. If somebody pointed it at me, I would believe that it was a gun.
Okay, and what did you do after you came into knowledge about this pepper spray ball?
It was, like I said, the defendant, showed us where it was at, it was recovered, and, she was taken into custody at that time.
Okay, now after that, did you take any statements from anyone else that was outside? If you recall?
Yes, ma'am. I remember talking to a witness. She didn't identify herself at that time, and she stated that she saw
Object
it.
to hearsay, Your Honor.
Okay.
I'll rephrase what you were saying. Without telling me what was said, did you take any statements regarding this incident?
Yes, ma'am.
Okay, and if you can recall, well, strike that. If you can recall, you recall who you took the statements from.
Are you asking if I can identify them, or are you asking if I recall who I took the statement?
If you recall who, like the names of the individuals who took the statement.
The person wouldn't identify herself to me.
Okay. I may have one more. One last question, Officer Barron. I want to go back to when you recovered this pepper spray ball gun. I don't know if I'm saying it right, but whatever it was. Do you recall Ms. Brooks telling you where it was before you came?
Yes, ma'am.
Okay, and was it in the house or on her person?
She stated it was on her person.
Okay, did she tell you when it was on her person?
When she was outside, yes, ma'am.
Okay.
She said she had it on her person outside.
Okay, no further questions. Cross-examination.
So, Morning, Officer Barron.
Good morning, ma'am.
Hello, okay, so, Ms. Brooks told you that she had pepper spray on her person, is that correct?
She admitted that she had the pepper spray gun on her. Yes, ma'am.
Okay, okay, all right, and you said that if you had seen that, you might have believed it was a gun.
Yes, ma'am. So I worked,
Okay, that, just right there.
yes, ma'am.
Okay, all right, so if somebody, now, based on what you just said, if somebody were pointing that gun at you, would you hang out for 30 minutes? In their immediate vicinity?
I don't know if that's a fair question to ask.
Well,
to be
that's the
honest,
question that
because I'm a
I'm
police
Sorry,
officer, so,
I'm gonna object to your proper question.
yeah.
No, I'm gonna overrule, I'm gonna allow him, and I'm allowing his answer.
Yes, ma'am. I'm a police officer, so I'm trained not to back down from anything. So, so no, I would not, I would be there. Yes, ma'am. I wouldn't allow somebody to scare me with a pepper spray gun.
Okay. Would you respond, that's a good answer. So in the face of that particular weapon that you took into evidence and what you know to be an actual firearm, would you have had any, would there be any difference in your response or your reaction?
No.
Any redirect? Yes, sir. So, Officer Barron, you said you've been a police officer for 5 years.
Almost, yes, ma'am.
Almost 5 years, okay. And, during your training and experience, have you come into contact with anybody who had a weapon on their person?
Yes, ma'am.
Okay, and, during those contacts, what will be your initial response?
Depending on the actual circumstance as to how that weapon was presented to me.
So, okay, let me give you a hypothetical. If the person had the weapon on their person, how would you respond?
I would try to remove that weapon, separate the offender from the weapon as soon as I possibly can safely.
Okay, and that'll be your response as an officer, correct?
Correct.
No further questions.
Thank you. Okay, so your training tells you to respond to pepper spray exactly the same way your training tells you to respond to an actual firearm.
Judge, objection, that's outside of the scope. I didn't ask him that. I didn't ask him to do pepper spray or pepper spray.
To be honest, yes, a pepper spray gun would be just as dangerous to me in that moment as a real firearm because it would not let me be able to see and react safely to the circumstances that surrounded me at that time, especially being in that large crowd by myself with my partner. So yes, technically I would have a very similar response to that pepper spray gun as I would a regular gun at that moment. Yes, ma'am.
That's your response. Fair enough. Thank you.
Yes, ma'am.
Hold on, officer, because our question along the lines of what they were just asking. When, I don't remember who asked you the question. Well, I think it was Ms. Ritter. But in response to Ms. Ritter's question, you said if someone pointed that device at you, you could see how it could be mistaken for a real gun.
Yes, ma'am.
So when you would have been responding, per se, you would have been responding as if it was a real gun.
Yes, ma'am.
Okay. Now my question to you, if you can recall, is what about it that would make you, a trained officer, mistaken for a real gun?
The likeliness to a real gun, about the same size as a regular handgun and similar shape. It has a barrel just like a regular gun does, and it has a handle and a trigger just like a real gun.
So unlike pepper spray that we hang on our keychain.
Correct.
That's a little
Correct.
thing.
Correct. Like a canister. It wasn't a canister. It was a pepper spray gun.
And then it had a place for the canister.
Correct. Correct.
Okay. Are there any questions based on my question?
Not from you.
Based,
I specifically asked him about the shape of the gun, the pepper spray, and why he would mistake it for a regular gun.
Okay, I don't have anything further based upon that.
Thank you, officer. Thank you. All right, any further witness on behalf of the people?
No further witnesses.
The people rest.
The people do it.
All right. Anything on behalf of defense at this time?
Can I have a brief research?
May.
Oh, you know what? Thank you.
It was Chris.
Judge,
You're not saying anything for the record, are you?
No.
Oh, okay.
I'm asking if we could take just a brief break from this case, because I have a question. I have something for Mr. News.
Mr. New, I'm finished with Mr. New.
It goes to his bond.
Mr. News bond? Okay. I guess.
Real quick, I appreciate it.
Yes, say real quick, Ms. Eason, I've never seen it. Have you heard that song saying it? Like you go on Sunday. I've never seen it. Okay, let's let Mr. New in. I'm tired. Let's quit. And then, no, that's not.
Oh, it's very brief, very brief relatively. It's like as soon as he gets in, I'll get out.
What's the issue? Is he has on a tether?
No, he was prohibited from driving by the
Well,
magistrate.
let me tell you, it could be a reason for that, now.
Yeah, there is, but I'm asking the court since there haven't been any issues with that.
Oh, I might not. Okay, come on. No, I might not. Okay, that's fine. Let's recall in. Case numbers 234453901 and 234503601. People versus Richard Allen. Ms. Ritter.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yeah, for the record, Your Honor, Janice Stevens, I'm appearing on behalf of Mr. Richard New. Mr. New, again, please say your name for the record, sir. Tell the judge your name, Mr. New.
Richard Allen New.
Okay, Ms. Stevenson.
Your Honor, we would like to be heard as the bond.
All right, you may.
At the arraignment, I believe, on this second case, Your Honor, the magistrate prohibited Mr. New from operating his motor vehicle. Mr. New hasn't had any problems with driving his motor vehicle. He continues to do everything he knows how to do to avoid having contact with complaining witnesses as this court ordered him to. And I would ask the court to permit Mr. New to drive his car.
Ms. Ritter, in response? It's just, I mean, go ahead.
I'll leave it in the court session.
I find it very strange that the magistrate would address somebody driving on an assault battery case. I find it very strange. So, you know, I normally don't prohibit people from driving who have valid licenses. I normally don't prohibit people from driving.
No open traffic.
Who was the magistrate? That's home.
Boyer.
Okay. I don't remember. Mr. New, if your license is valid, then you can drive. Okay, be safe out there, okay?
I got a good record.
You got a good record? All right, keep it good, okay? All right, then you can drive. They'll bring you out a copy of the order, but you can drive, okay? All right, you're welcome.
And now can I go take this break?
Oh, now, okay, 'cause we've been on the break. We've been on the break. Okay, break. We've been on the break. Okay.
I just want to let you know about this.
Why? Oh, you mean you feel like the facts didn't go?
Yes.
Oh, I'm like, why are they talking about that? Oh, it's fine.
Yeah.
Okay, well, the call, cause
I'm gonna keep calling.
she going to jail. She gotta get that check.
Yeah.
Well, really what I need to do is call. Oh, when you get them.
Yeah.
But I need to be clear. They need to take custody, that they need to take custody.
All right, so I'm gonna keep calling.
I guess they're on break. I'm on mute. It's your sister council. I mean, who do you want? I don't know if I want. Mr. Flanagan.
That's right.
You need to go.
Yeah, no problem.
She pulled across the street to pick up her neighbor's son, who she refers to as her nephew, to take him to his mentoring program. And then some people appeared in her neighbor's driveway, and they were doing some hand signs or whatever. And then at a certain point, she says Miss Brooks came outside and she went to her vehicle and she pulled out what appeared to Miss Watkins to be a weapon. Miss Watkins calls 911. She's telling the police, come, this lady have a weapon. She sits in the car for at least 25 minutes, but her testimony was that she waited for the police and they didn't come for 2 hours. So she might have sat there for about 2 hours. I don't know. And then eventually the police came. That's a little disheartening, but I'm gonna move past that. So the police eventually comes, they take a report, and the officer says he gets there, he investigates, and then he has to have Miss Brooks go into the home and get what turns out to be turned out to be a pepper spray. He said like a pepper spray ball gun or something, a pepper spray gun. They get it out of the house and then they take Miss Brooks into custody. And Miss Watkins testified that Miss Brooks brandished the paintball, not paintball. I was trying to stop myself from saying paintball this whole time. Pepper spray gun at her, that she actually pointed it at her. And then she was on the porch, she had it in her waistband. So the court was showing a video that Ms. Watkins said she began to record this video once after she called the police. And then, you know, she began recording this video. If I had a neighbor that was acting like Ms. Brooks was acting on the video, we wouldn't get along either. We wouldn't get along. In fact, I probably would be telling her, you know, ma'am, take your ignorant self in the house. You turning your tail to me. You well past grown and you tooting up your buttocks in front of your children that you know, I got into an argument with a young man, but we ain't that young because this happened last year. Okay. And they said something about, you know, they wanted me to do something or go somewhere or something. And then I said, oh, I would never do that because that would give my daughter the wrong impression. I said, I live certain, you know, standard. I set a certain standard. And that would give my daughter the wrong impression, like I lived a lie, like I'm talking a lie. And they was like, your daughter, you know, ain't your daughter grown? She is. She is. And I would not do anything in front of my daughter that I wouldn't want to see my daughter do in front of me. Now, Ms. Brooks' behavior on that porch, it was just like really ridiculous and unneighborly and unadultish and everything else. Okay, so when we get past all of that foolishness that was going on that video camera from a real grown woman setting the poorest example she could possibly set for anybody looking, now the court has to determine if she committed an assault as to Ms. Watkins. So, reading the jury instruction, 17.1, the definition of assault, and it is for use where there has been no battery. So the defendant is charged with crime of assault. Okay, to prove this crime, the prosecutor must prove that the defendant either attempted to commit a battery on Ms. Watkins or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of the person of another or something closely connected with the person of another. Second, that the defendant intended to either commit a battery upon the complaining witness or to make the complaining witness reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery or appeared to have the ability to commit a battery. Ms. Stevenson, in her closing argument, she says, "It's no way that we can have a battery, an attempt to commit a battery. There's no way we can have an assault because Ms. Watkins clearly was not afraid of Ms. Brooks." And every time that argument is made before this court, I immediately go to the psychological concept and theory that people are either in two modes when they approach danger: fight or flight. The person who is flight, they gonna run. They see the gun, oh, they gonna run. Oh my goodness. A person who is wired to fight, they gonna stand there and say, "Fool around and find out. You pull yours, I pull mine. And let's see who the quickest draw and who the quickest on the trigger." Now, if I take the defense's argument, that means that a person who is wired to fight can never be assaulted. They can never be assaulted. They can never, because they're not scared. Now, I say here all the time, I ain't scared of you. I ain't scared of you. Now, it could one day be to my detriment because I could lose. But in the moment, I ain't scared. But that doesn't mean I can't be assaulted. Why? Because you had the ability to commit the battery. You wanted to make me think you could commit a battery. I don't know if she pointed the gun, the pepper spray at her or not. Now, I found Ms. Watkins to be credible. There's nothing other than her testimony to support that the gun was pointed at her. But what there is support for is that on that porch, she had that pepper spray in her waistband as if it was a weapon. She was pointing at it. She was doing a whole bunch of other ignorant stuff, turning around, putting her tail out. She was saying some stuff, doing all like this, right? Now, the law doesn't allow Ms. Watkins to shoot her from across the street. That would be, I was probably over, but the officer said he would have took her down. He would have tried to disarm her if it was in her waistband. Now, nobody asked him, and I didn't want to ask him because I already knew the answer. If she pointed that pepper spray at him, she probably wouldn't be sitting here at that table today. They would have had her funeral already because he'd have took her down. He would have said, "Drop the weapon," and been ready to shoot her and kill her. She was messing around with the right person. Ms. Watkins, who apparently has been very patient, I guess. I don't know who fought and who started the argument. But what I know is that Ms. Brooks was clowning on that video. Ms. Brooks was inciting her family, encouraging foolishness from her children, and acting in a manner that was so ridiculously unneighborly. And the court does believe that the defendant attempted to commit a battery. The defendant acted in a way that would cause a reasonable person. I was going to address that too. If I pick up this highlighter and I do like this and aim this highlighter at the plexiglass, because we see everybody got plexiglass. If I aim this at the plexiglass and then Ms. Ritter say, "The judge assaulted me," that's unreasonable. Ms. Ritter sitting down, we got plexiglass right here. Ms. Ritter say, "The judge was assaulting me when she threw that highlighter." That's unreasonable. They would say, "That's unreasonable." And we wouldn't, we'd be like, "Girl, she wasn't throwing that at you. That's unreasonable." Well, it's the same thing. If a person stares down what they believe to be the barrel of a gun and they don't flinch or do or what, That's unreasonable. Their response is on the other end of reasonableness. The reasonable person wouldn't think I was throwing this highlighter at them. And the reasonable person would have thought that was a gun, and they might have ran or pulled off or grabbed the boy or went. But the fact that I'm acting in an unreasonable way doesn't mean I wasn't assaulted, because I read it again during defense argument. And I did not see in any of these bullet points where it said, and the person has to have believed that they were in fear. It says the defendant either intended to commit a battery or make the person make the complainant reasonably fear. So that intent is on the defendant. It's not on the complainant. It's saying the defendant intended to make you think this was a gun and I was gonna shoot you. Whether I thought it or not, that's besides the point. When you did it, you thought it. You wanted to make me fear that you had the ability. And then that the defendant had the ability or appeared to have the ability. So when I pull out this non-gun, I appear to have the ability to shoot you, which I wanted to make you scared. But then you didn't move, she didn't drive off. she didn't do it. So now I'm stuck with the fact that it ain't even a gun. And then if she had came over there and beat her up, because you pulled this fake gun on me, now we're in a different situation. Yeah, the court finds that people have met their burden beyond a reasonable doubt that Ms. Brooks is guilty of one count of assault or assault battery. And quite frankly, I think she's guilty of brandishing a weapon. Now, I can't talk about, I don't work in a warrant office. I also think she's guilty of a felonious assault. That ain't my business. That ain't my business. I don't sign the warrant. I don't do the stuff. That ain't my business. But she's definitely guilty of assault. And the court so finds. I'm gonna set the matter for sentencing.
Judge, will the court consider immediate sentencing?
No, I want a pre-sentence investigation because she acted in such a way on that video.
Yes, sir.
I want a pre-sentence investigation because I want a pre-sentence investigation. Because this time it might result in something else. The end of this might result in something else. And she needs to stop. Now these people are neighbors. And what you need to understand is that Michigan is actually a stand your ground state. We don't talk about it much, but I don't have to back down from you. Nobody has to back down from you. And whatever the issue is that you all have a disagreement about, you need to stop, because one day, somebody for real is going to show you that they're not scared of you or your children or your children's boyfriend. And one thing I know about bullies is that bullies are bullies until you show up and show them who you really are. And so you should stop. You should stop. You're too old for that. I can't imagine my two neighbors on the other side of me not getting along with me. I can't imagine it. And it has never occurred in my entire 57-year lifetime. And I have lived in the hood of the city of Detroit, and it has never happened to me in my entire lifetime. Never. I have lived in apartment buildings. I have lived in houses. I have lived on the corner. I have lived in the middle of the block. And it has never happened. Why? Because I can't even imagine what me and my neighbors have to talk about. If they don't like me, we don't even have nothing to say. If I wave at you and you don't wave at me, don't wave back. You don't have to wave back. If I make a mistake and ride over your grass and that makes you angry, stay off my grass. I do apologize. I didn't mean to ride on your grass. I'm sorry. But if I don't, and I say, well, put something up on your grass. Put something to block me from riding on your grass. Our driveway is too close. Then you supposed to say, yeah, and you go get one of them big old boulders and make me mad and put the big boulders. You put the big old boulder so I won't drive on your grass. That's it, that's all. Now I can't do nothing, it's on your property. Okay, so I don't even know what y'all arguing about, but you need to stop because it's gonna send one of y'all to jail. And one day it might send one of y'all to prison. If y'all keep up, because y'all gonna keep fighting. And then the next time it might not be a taser, not a taser. Pepper spray gun. Y'all gotta stop. Y'all gotta stop. You have to stop. You have to stop. And you gotta tell your kids to stop. Because it would be a shame for your kids to get you locked up. It will be a shame for your kids who you have been a bad example to get you locked up. That don't make sense. What I saw in that video, that don't make sense. Okay, I'm sorry. We're gonna set them out of sense. I ain't gonna have to say nothing that's sentencing because I've said it all right here. We're gonna set them out of sentencing. Mr. Flanagan, let's go to. Let's go to, and let me say this. Let me say this because it just came in my spirit. When you leave here today, you're still neighbors. Now, Ms. Brooks, I don't want to have to give you credit for time served on the day of your sentencing. What do you mean by that? I don't want you to have to wait for your sentencing locked up. I promise you, there's nothing in the entire world, nothing, not the apocalypse, not, somebody get ready to bomb the whole block. If you the only one that knows somebody get ready to bomb the whole block, Ms. Watkins she's gonna have to perish. Because if you say to Ms. Watkins, somebody get ready to bomb this whole block and the block don't get bombed, and she told me somebody's gonna bomb the whole block, you locked up. You locked up. Don't say anything to her. Don't say anything to her. And tell your kids, they acted out on that camera too. And I would hate for them to get you locked up. I don't know if they live with you or if they were just visiting. But everybody's behavior better line up with my no contact order. Everybody's behavior better line up with my no contact order. Because one thing we know for sure and two things we know for certain is that Ms. Watkins gonna use her cell phone to record you. Okay, so don't get locked up in between these sentencing dates. What about February 12th? Any sentences that day?
No.
Court's gonna set the matter for sentencing February 12th. 9:00 a.m. And she is going to submit to a pre-sentence investigation and substance abuse evaluation to the probation department. She is in the building. She's gonna go over to probation and schedule that right now. Let me say this, if you fail to participate in this pre-sentence investigation, I am going to assume that you are in agreement with me imposing the maximum penalties allowed under the law. You need to cooperate with the pre-sentence investigation. Otherwise, all that's gonna be in my mind, I'm telling you now, so it's not a secret. If you don't participate in that pre-sentence investigation, the only thing in my mind is that video. That's it. That's the only thing in my mind. And if that video is the only thing in my mind, you going to jail. I try not to keep secrets and stuff and hide. I want you to know exactly what to expect. If the only thing I'm gonna consider is that video, you're going to jail. So the pre-sentence investigation in your case, it is critically important. It is critically important. Anything further?
Your Honor, we have heard the court and certainly Ms. Brooks intends to comply with this court's orders. I would just ask, because of the volatility of the situation, that everybody on both sides be reminded of the court's mutual.
Okay, no. Ms. Watkins down in here and saw I was almost, she's giving it almost loose cake, but she pulled down her mask and stuff. She knows. I hope everybody know this. I take this here, this little black robe that they make you buy. Oh no, this is the one the court did that. They finally bought it. That they, you know, they get. I take this serious. This is not a joke. This is not a joke. And so nobody's gonna talk to anybody. I can't even. I mean, I just think I can't even imagine. Like you come when I come in my driveway. Then my neighbor whose house right there is next to my driveway. Then we just, I was like, hey, how you doing? Hey, Happy New Year, you know, Merry Christmas. Yeah. I mean, but me and my neighbors, who I've only known at this particular location, right, for like 5 years. I mean, we literally would give each other keys to our homes. We literally will say, hey, I'll be out of town for 10 days. You got me, I got you. That we literally would say, hey, there's a package on your porch. You want me to get it? My neighbor on the next side of me, I tell his daughter, hey, you need me to do anything for your dad? Look out for your dad. I never heard of this. This stuff I only come in contact with here in this courtroom. It's a book I read on a regular basis, and it says that everybody should try to live peacefully. Peacefully. None of this, but no contact. There's nothing in the world of communication about. Ms. Watkins, if you know the apocalypse is coming, don't tell her she's just going to be caught in it. Okay? Nothing to talk about. All right, anything further?
Nothing on behalf of Ms. Brooks, thank you.
All right, so Ms. Brooks is going to have a seat in here while the officer dismisses the people. And well, are these people on the back row, they from Ms. Brooks?
Yes, ma'am.
Okay, so then they're gonna stay with Ms. Brooks and then you're gonna release the people. Did you need to speak to your witnesses?
No.
Okay, so let them leave first with the lieutenant. And then. And I think that concludes.
No.
Do we have any dates we had to go over?